right, my friends, J.R. Dukes at your service. Appreciate everybody joining me today. Let me get 1 second here, make sure everything is working like it should be working. Appreciate everybody taking time, spend your lunch time or your morning with me. We have an important video that we're going to go over today. Looks like we're good on X. Hello, everyone. Got quite a few on X today. And YouTube, Facebook is looking good, and Twitch. Fantastic. So once again, welcome to everybody. If you haven't done so already, do me a quick favor. Put inside the chat, say a quick hello. Let us know where you're from. And I want to let you know today is going to be what we call a open platform. And in the open platform, we are going to be allowing you to call in, allowing you to show up by video. I'm going to post those instructions in just 1 second, although it is very simple to join. This is something we've done a little bit on and off before. Generally, I'll have a guest to appear on the program and discuss whatever the topic is for today. What I'd like to do from here and going forward in the future is just that simple. Talk to you. I want to have a conversation. I'm all about ending indoctrination, talking about the subjects on a day-to-day basis that affect our daily lives. I'm a firm believer that when you understand better, you can live your best life possible. It's really just that simple in my estimation. So as we're filling up here, great, good. I'm glad to see everybody coming in. I got a few other quick notes before we get into the main subject today. And today's main subject, as you probably guessed from the thumbnail, is we are going to be taking a deep dive into the United States Supreme Court's decision that we're all very eager to await whatever the final decision is going to be pertaining to former President Donald Trump. And also, if you haven't noticed already, please take a moment and answer that poll. I would like to see exactly what everybody's opinion is. We'll take a look at it later on in this discussion. But essentially, there's 2 or 3 outcomes that the U.S. Supreme Court can put forward, and each one of these decisions has a very, very serious impact on, of course, former President Donald Trump and, frankly, our nation as a whole. And I'm not trying to be very dramatic about this. I'm not trying to make this seem like it's something that it's not. This is extremely important for each and every one of us. I would say at the end of the day, if the Supreme Court does not get this right, the office of the presidency is basically going to be swallowed up by the judicial branch of government. And again, we're going to go into that in just a moment, and we're going to take a deep dive on that. All right, we already got some folks in the chat. It's always good to see you, Yvonne. Thanks for showing up from New Mexico. All right, let's let me give you some instructions here. If you'd like to join the chat, you can simply call in. I'm going to post a link right here for you. All right, this here is the link. It's pretty easy. If you have an Apple device, if you have a Google device, either way, it doesn't matter. You can join by this link that I just put in the chat. I believe on the iPhone, there's an app that really makes it easy that you can simply download off of the App Store. Just type in StreamYard. It's called their Guess app. And once you download it, you simply click on that link, and it will allow you to join. You can use your video, of course, if you like to be on camera, or you can simply just turn off your camera just by pushing that icon right there. You'll see it at the bottom of your screen. You'll have the icon for the video feature, and then, of course, you'll have the mute feature as far as if you need to black out the background noise or whatever. So anyway, the 2 options are real simple. You can join by phone or you can join by video. Either way, we'd love to have you. Once you click that link, in case you're wondering, once you show up on my screen right here, be prepared to go live, because I'll put you on and we will discuss any questions or issues you have about this subject or related subjects that we're discussing today. All right, one other quick thing I want us to take a quick peek at. I thought this might be an interesting way to start diving into this. We're also waiting for President Trump's pick. And let me pull this up right here. I made this list, as many of you probably remember, pertaining to what are the possible choices that President Trump could pick. So let's go ahead and take a look at this. I want to minimize myself just a little bit. Let's take a look at this. There's one other choice that I want to talk about that's really kind of caught my eye. And of course, we have, I believe it's North Dakota Governor Doug Burgum. We have J.D. Vance. I believe he is a Ohio representative, or maybe he's a senator. I think he's a senator from Ohio now. At any rate, you got Mark Rubio, of course, from here in Florida, senator. You have Tim Scott, the other senator from the great state of Florida, which, of course, is where I'm broadcasting from. You have Arkansas. I don't know if he's a representative or senator. I'm almost embarrassed to admit that. I think he is a senator. That's Tom Cotton. You have Byron Donalds right here in Florida. By the way, let me know who you think President Trump should pick as his vice president, whether it's on this list or not. I'm curious as to who you think Trump will pick. I don't think we're going to have to wait long for the decision. The longest we're going to have to wait is, of course, the convention that is coming up very quickly this next month. And of course, we also have the Trump sentencing in the so-called, what is that, the documents case, the so-called hush money case. We know what that's all about. We got Elise Stefanik from New York. We have Dr. Ben Carson, and I've made no bones about it on this program. Several times we've discussed this. I really think Ben Carson is a real possibility for President Trump to pick. Of course, we're going to skip Glenn Youngkin for 1 second, but Governor Abbott of Texas, Governor Sarah Huckabee Sanders, Arkansas. And remember, she used to be the press secretary for Donald Trump when he was in office. I don't know if she was the first. I think she was his first or second secretary, or press secretary at any rate. And of course, let's see, Carrie Lake, which was kind of a long shot, and same thing with Tulsi Gabbard. And of course, that one governor, I think from South Dakota, her name is escaping me. If you know her name, you're welcome to put it in the chat. However, she came out with that book and talked about shooting her dog, and that pretty well shot her chance of being Trump's VP, in my opinion. It's just an issue that he doesn't need to have to dig into unless, I mean, really, you don't really want a self-inflicted wound. You follow what I'm saying? Now, here is the surprise that kind of surprised me. And I was thinking to myself, man, this would be ingenious if Donald Trump picked him. And that is Governor Glenn Youngkin, the current the current governor from the state of Virginia. I believe they appeared together this last weekend. And I don't know what you think about it, but I think it would be an interesting pick. And Yvonne, I agree with you. I was definitely thinking Carson on my list. The only reason I don't think Donalds has a chance, and again, it's just my opinion, is simply because he's inexperienced. I believe he's a newer representative. I think that on the job experience would be a serious issue. And I'm sure that President Trump is thinking about that along. To be honest with you, I'm not sure how Marco Rubio is going to work out, because if you remember from our Constitution, there's only a few requirements that a potential president or a presidential candidate has to have. And one of the requirements, because the founding fathers wanted a candidate that didn't just represent one area, but essentially represented the country, and that is the president and vice presidential candidate cannot be from the same state. So, of course, President Trump is from Florida. He changed his residence from New York State to here in Florida. And then you have the sitting senator, Marco Rubio. I believe he's now the senior senator, because the other governor, Tim Scott, was a former governor here in the state of Florida. He was more newly elected to the Senate. I could be wrong, but that's my recollection. At any rate, what a great idea. Somebody like Glenn Youngkin. He kind of appeals to the middle of the ground type of voters. Virginia is generally a pretty solid blue state, at least recently as far as elections go. However, they elected Glenn Youngkin. Can you imagine the panic that would cause in the Biden administration, because they're not really thinking of Virginia as being in play. However, if President Trump was to pick him as his VP pick, I just think that might actually work. I don't know how y'all feel about that, but that would definitely be on my list of, at least it'd be something to seriously think about it. I'm not sure, just thinking out loud here, that President Trump really wants two white men to be the face of the ticket. We should not really engage in identity politics. We should be electing the best people to whatever the position is. However, we all live in what I call the real world. And in the real world nowadays, unfortunately, these are considerations that are given to almost every position. If you remember, in the U.S. Supreme Court, President Biden had to put up a black female, and that's exactly what he did in the Jackson justice. And of course, she is probably as ultra left as the justices can possibly be. All right, so Glenn Youngkin, interesting, at least in my mind, definitely an interesting possibility, and we'll just have to see how that works out. Here's a quick video. Let's take a peek at this, and then we're going to move into today's topic. So we're going to go ahead and share the screen with you here. Make sure I get the right one pulled up. Okay, this is a video. This is a new video. I believe it, like I said, it's from this weekend, and it has Governor Glenn Youngkin with Donald Trump. And let's just kind of listen in and see what this commentator, this is from their local Fox 5 station right there in.
Possible running mate alongside former President Donald Trump. The pick is expected to be announced at the Republican National Convention next month in Milwaukee. Tom Fitzgerald, live for us tonight in Alexandria. Fitz, the governor was in our area just this morning.
He sure was, just behind us across the Potomac River over in Maryland. The governor appearing with a group of governors today at a trade event at National Harbor. Now, keep in mind, even though Glenn Youngkin has had several setbacks the last couple of years, like the Potomac Yards Arena deal falling through, like Republicans losing the last general election nationally, Glenn Youngkin is still viewed as a rising star within the Republican Party. Now, just 2 weeks ago, President Trump and Governor Youngkin met privately at the Trump National Golf Course in Virginia. Now, Professor Stephen Farnsworth at the University of Mary Washington says he believes that Glenn Youngkin is a viable and very real vice presidential contender for the Republicans. The governor himself today avoided any VP talk. Instead, he tended to focus on his bipartisan credentials.
Virginia is focused on getting things done, and we don't really fight about politics. We argue about how best to serve businesses, our workforce, and the increasingly growing number of people that are choosing to build their lives in Virginia.
Youngkin is an early endorser of the former president and has not done the sort of things to make an enemy of Donald Trump that some Republicans in Virginia have done.
Now, to throw a little more fuel on this fire, there's this. After this week's first presidential debate, Donald Trump is expected to hold a rally in Virginia. Now, what's interesting about that is Governor Youngkin, we're told, is going to appear with Trump, and that would be the very first time both of these individuals appear together during campaign 2024. What are people saying about this? Well, Fox 5 heard varying opinions from folks about Glenn Youngkin as a vice presidential pick.
I think he'll do a good job. I think he'll pick a person that hopefully knows how to run a business.
Everybody's got to move up, yeah.
Mm-hmm.
Yeah.
Do you think he could?
I have no idea.
To me, it doesn't matter who's the governor. I could be the governor, but if you're not forward thinking and helping the people, sorry.
Now, for his part, Governor Youngkin described that meeting with Trump as a strategy session for both of their political teams to get together and discuss what Youngkin views as a very competitive political slate here in Virginia right now. Recently, both Roanoke College and Fox News released presidential polls showing, in their view, the Commonwealth between Joe Biden and Donald Trump as tied. We're live in Alexandria tonight. We'll send it back at you.
Okay, so just an interesting take right there to show that I'm not the only one thinking this. I've heard rumblings and some rumors here and there pertaining to Glenn Youngkin being the actual pick. I think it's an interesting pick. I'm not sure, again, if I would pick him, but it's an interesting pick, and I think it would definitely be great to see Virginia in play. So I don't know. I just think it's, again, it's an interesting pick, and we'll have to see exactly what transpires with this. All right, let's switch gears. We're going to move into now the case that we're going to, that's pretty well the meat of what I want to discuss right now. So let's go ahead and, again, I'm going to share my screen with you, and we are going to listen, and I'm going to make comments as appropriate pertaining to this here. Additionally, I have some case law that I've looked up pertaining to this that I think will help us and help the discussion. So we're going to listen to this together. As I said, let me make sure I got everything set up exactly the way I want it. Okay, so here we go. This is the case. I believe it's called Trump versus the United States is exactly the way this particular case is titled. And we're going to pick it up right near the beginning of the actual arguments that were broadcast live. Remember, the United States Supreme Court generally does not allow cameras in the courtroom. So they were kind enough at least to go ahead and allow live recordings so that we can hear these cases. And I can assure you there are a ton of very important cases pending right now in the United States Supreme Court. Just to give you a little bit of a nugget here, there's another case involving something called the Chevron doctrine that, in my opinion, probably outweighs the Trump case. I mean, it's really that important, and we'll get into that at a later time. So this thing here says it's 3 hours long. It's not quite that long. And, I've already got it set to go at the most major points that we need to talk about in relation to this case. Actually, Donald Trump actually filed, of course, as you would expect, an additional brief on this particular case. And we're going to talk a little bit about this too, because I think the president, via his attorneys, have made some very interesting points and explains just how important this is. And I want to say this before I start the actual taper. You have to understand, if the Supreme Court does not get this right, and I think that's one of the reasons it's taking so long, one of the justices said correctly that they are writing a rule for the ages. And I think that is a very good and proper way to explain this to everyone. They have to get this right. This is going to be a case that they're going to reference forever how long the United States is together as a country. It's really that important. And as I was telling you earlier, the reason this case is so important is if they don't get this right, in my estimation, what we call the deep state will win. And the reason for that is simple. If the president does not have total immunity, or something very close to total immunity, effectively, you're going to have the judicial branch of government take over the presidency. Please recall that back in high school, maybe you learned a little bit about the government, the United States government. We have what we call 3 co-equal branches of government. To put it in layman's terms, and just to make it quick, we have the executive branch, which of course is the president, or the police. They're kind of all the same thing. You have the judicial branch, which of course is the court system. We're all familiar with the court system. And then finally, we have the legislative branch, and we most commonly think of that as Congress, the House of Representatives and the United States Senate. And it exists both on a federal and a state law. Again, I don't want to get too deep into the weeds, but the way the founding fathers set all this up was that each branch is co-equal. Each branch has the same power as the other branch. It's supposed to serve as what we call a check and balance on each branch. So what we have going on in this case, and this is why this is so serious, this is the first time in American history that you have essentially the judicial branch, aka Fannie Willis, Alvin Bragg, all of these idiots are essentially engaging in what we have called lawfare against the party they don't like, against the person they don't like. And I can assure you of something. Now that this bell has been rung, if the Supreme Court does not get this right, we're going to have this as the normal course of business in the United States. It's just the way it's going to be. Now that the Democrats have opened this door, the Republicans have no choice but to reciprocate. For example, if the Supreme Court does not rule correctly on this case, it's pretty well a given that when President Joe Biden leaves office, he's going to be prosecuted immediately by one of the 2,300 or more local DAs. And can you imagine that? All these little bitty individuals, if you will, have the power to put a former president in jail for acts that they may or may not have committed while they were the federal president of the United States. It's an outrage. It's never been like that before. But the crimes, at least in my mind, immediately that Joe Biden can be brought up on are the following. How about the border? Allowing all these illegals to come in essentially unchecked, unfettered. And we have had at least 3 murders by my account because of President Joe Biden. Murder number 1 was that 12-year-old that was just killed by them 2 illegal immigrants in Houston. You had, was it Laken Riley in Georgia, killed by another, I believe it was a Venezuelan immigrant. And the other case is escaping my mind. But at any rate, there's 3, 4 cases just recently that has transpired. And I can assure you, President Joe Biden, in theory, could be held culpable for murder, if not some reduced charge of manslaughter. But at any rate, that all carries substantial prison time with it. So may or may not agree with me, but I can tell you that once these doors are open, they're just that open. If you have any questions in the meantime, like I said, feel free to hit the link, call in, video in. We'll take your questions or just type them in and I'll do my best to get to them. We're going to go ahead and start listening to this right now, and we're going to pause as needed. Again, this is the actual hearing that was broadcast live, and we're going to go over it together.
Judgment, so to speak, of the Article 3 courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
This guy that is talking, the first guy that was talking with the real raspy voice, that is Donald Trump's lead attorney. I believe his name is John Saucer is how you pronounce the name. And then, of course, the other gentleman you hear speaking is the Justice Clarence Thomas that's actually asking the question.
I'd point the court to 2 cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives, where the court adopted the outer perimeter test. And this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case. Here it would be the indictment.
Well, what if you have, let's say, the official act is appointing ambassadors and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches
the Brewster case is a case all the way back from the 1970s around the Richard Nixon era. And essentially you had a senator named Brewster that litigated all the way to the U.S. Supreme Court saying he could not be held for some type of bribery. And of course, he lost at the court at that particular time, and he was eventually convicted of bribery. But it is a Supreme Court precedent, and that's what they're talking about.
Is the court the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay, it's not.
Appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively, at least in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the recommendations clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case. And that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can be alleged, but it has to be proven.
Okay, this lady here is Justice Sotomayor, if I'm saying her name correctly. That's who you hear speaking. And essentially, what they're debating is what is the difference between a president carrying out what's called his official responsibility versus something that would be less than an official responsibility. You heard him earlier talk about bribery. So, in theory, a president could be talking about a policy. And of course, that's part of his official job. But as soon as he starts discussing bribery or some other crime, he's falling out of the scope of his normal and usual duties. And that's where the Supreme Court justices are trying to figure out what to do. And if they draw a line, where is that line? What does that line look like?
Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say, if you stay by it, if the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts?
This was a question that one of the justices on the Court of Appeals, I believe it was originally in the DC Court of Appeals. You may remember hearing it from television. One of the justices said, hey, what happens if the president was to order SEAL Team 6 out to kill their rival? Would that be something that is an official act, or could he be prosecuted for that? And of course, at least in my opinion, the attorney for President Trump messed that one up big time. The proper answer would be something like this. Of course, if the president was to order something that's illegal, inhumane, violates treaties, something along these particular lines, an officer, a soldier, has no duty whatsoever to carry out that type of illegal order, period. That's the end of that discussion. And of course, we'll see how this guy answers to see if he does any better.
For which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain.
What she's talking about there, if you don't know, is that President Obama, at one point in his presidency, ordered that some American citizens were effectively killed in a terrorist strike that he decided to go after some terrorists. And like I just said, some actual Americans were killed. Again, if immunity is not granted to the President of the United States, President Obama could be brought up on murder charges for killing American citizens and killing them without due process.
And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up. Instead, they passed an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that. A president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this
Immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president.
Now, remember, the liberals on this court, they're extremely upset that a president, specifically President Donald Trump, could get away with, in their words, crimes of some nature. They haven't said exactly what the crime would be. They're using hypotheticals at this point. But if you notice, at least initially in this questioning, it's all of the liberal justices that are going ape about this particular case. Now, they would want you to believe that a president or some officer of the government having immunity or even total absolute immunity is outrageous. It's something that's never been done, but that's not true. Don't believe those lies. Judges, for example, have total immunity for their job. As a matter of fact, the Supreme Court justices can never be civilly or criminally liable for anything they do while they're doing their job. Same thing with Congress people. They have complete immunity. Also, I'm sure you've heard of this in the news, and it's something called qualified immunity. You heard the justice just then mention this. Now, qualified immunity is what the police have. And make no mistake about it, qualified immunity is a very strong immunity doctrine. Have you ever seen a police officer held to where they had to pay damages money-wise? And let's be honest about it, it's rare when they're ever criminally charged or prosecuted under the laws. It's just the way the system works. So when you hear them say, oh, if President Trump is immune, it's really an exception. It's really nuts. It's something that we don't enjoy in our country as a matter of history, because that is a complete a complete lie. Also, one other thing to remember is that back in the 70s, Richard Nixon, and I think at the beginning of the 80s, they had a case too. It has for a long time, it has been a ruling of the Supreme Court that a president has 100% immunity for civil issues arising from his behavior, no matter what they are. 100% total immunity. So it's not like it's a new thing. It's just that it's never been brought up. And President Trump and his attorneys do an excellent job of mentioning the specific point in his brief. And we may or may not get time to look at that. But I just want you to remember that this is not a novel legal argument like Alvin Bragg would try to bring up, or even Fannie Willis for that matter. This is something that's been part of the American tradition for a very long time. You could never sue a former president or a current president of the United States for anything relating to their job. It's just the way it is.
President or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what
this is
are
Jackson, Justice
acts
Jackson,
and what are
by the way.
not? I mean, I'd understood that even in the first of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official act, so then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right. So my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess, even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in, because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is, in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question before my colleagues take it over here? At the beginning of your analysis, when you were giving your opening statement, you were talking about you suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is, at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution," and everybody cried out against that.
No, I understand, but
see, the liberals don't like the fact that Donald Trump specifically would get away with this crimes in their mind, whatever alleged crimes. They know that if they can't find a way to take Donald Trump out, then he is highly likely to win in this upcoming election. They keep going around almost in a circular type way, saying something to the effect of, well, why should this one man get away with a crime? This man is not above the law. You know, they keep saying that. No man's above the law. No person is above the law. And you know what? That's all fine and good. But the reality is this. It may be the case that instead of worrying about whether one man, one woman gets away with an alleged crime that has never happened to this particular date, we may want to worry about us and our country. In other words, I would phrase it like this. It might be worth taking a chance that some president might get away with some future hypothetical crime to make sure that each and every one of us and our families and our loved ones and our country are secure. Let me know if you agree with that or not.
Since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution. No?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted.
Counsel, on that score, there does seem to be some common ground between you and your colleague on the other side, that no man's above the law, and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question becomes, as
I believe this is Justice Alito that is speaking right now.
we've been exploring here today a little bit about how to segregate private from official conduct that may or may not enjoy some immunity. And I'm sure we're going to spend a lot of time exploring that. But the DC Circuit in Blazing Game, Chief Judge there, joined by the panel, expressed some views about how to segregate private conduct for which no man is above the law from official acts. Do you have any thoughts about the test that they came up with there?
Yes, we think in the main that test, especially if it's understood through the lens of Judge Katsas' separate opinion, is a very persuasive test. It would be a great source for this court to rely on in drawing this line. And it emphasizes the breadth of that test. It talks about how actions that are, plausibly connected to the president's official duties are official acts. And it also emphasizes that if it's a close case or it appears there's considerations on the other side, that also should be treated as immune. Those are the aspects of that we emphasize as potentially guiding the court's
And that left open in that case the possibility of further proceedings and trial.
Exactly right. And that would be a very natural course for this court to take in this place. The court can and should reverse the categorical holding of the D.C. Circuit that there's no such thing as official acts, especially when it comes to.
But you'd agree further proceedings would be required.
That is correct. There would have to be, and I would point the court to Anderson against Creighton, where the court said there'd be kind of two stages of these further proceedings. There's looking at the indictment itself, or in that case, it was a complaint, but look at the charging document itself and see whether on the face of it, this is alleging official acts. And if not, or it can't be determined, then there'd be a factual proceeding. And all that under Mitchell against Forsyth and so forth would have to occur before any other proceedings in the district.
Can you, Mr. Sauer, go ahead.
A quick comment, just like no reply, was just saying the problem with this, and you kind of heard the justices talk about this, is, and if it probably will go this way one way or the other, and if anything short of no immunity, frankly, is going to be a win for President Trump. I'm not sure how much of a win it's going to be for the presidency in the future, and we'll talk about that later. But the reason for this is because if they rule that a president has some type of immunity, even qualified immunity, like they were just discussing, what they're talking about is the case has to go back down. And essentially what that means is it has to be remanded. It has to go back to the lower courts for them to iron it out. And then what you're going to have in the future is every president, starting with President Trump, is going to have to show up in court and essentially litigate that what they did was either an official act or not an official act. And then each and every decision will be appealed all the way back up to the U.S. Supreme Court. Remember, it's not unlike the United States Supreme Court has not already ruled a president has absolute immunity, which means 100% immunity. They did that in the civil context. Now they're heeing and hawing and trying to figure out what to do in a criminal type of setting, in a lawfare type of state that is going on right now. So just kind of keep that in mind as you're listening to this.
Mr. Sauer, you began by explaining why you believe that immunity from criminal prosecution is essential for the proper functioning of the presidency. But my question is whether the very robust form of immunity that you're advocating is really necessary in order to achieve that result. So just to take one possible alternative, suppose the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent and the information that was provided to the president at the time when the act was taken. Would that be sufficient? Or if it is insufficient, why would it be insufficient?
That might be a much better rule than what emerged from the lower courts here. We think it would be insufficient because, again, that long line of cases talking about using the president's motives and the intrusive sort of consideration of the president's motives as transforming acts to official and unofficial would come into play. And of course, once you can make that allegation, all of a sudden you've opened the door. You no longer have a per se clear, bright line rule. You have a determination in every single case.
Well, what if it were not?
He's exactly right. If they grant anything less than total immunity, what's going to happen is you still have kind of the same problem. It's not like having no immunity. No immunity results in the deep state taking over the branch of the presidency. You no longer will have anybody that could rise up as a populace and reset the country the way we think of the presidency today, if that was to happen. Now, even with what we would just, why don't we just call it qualified immunity? With a qualified immunity, which is kind of middle ground, so to speak, you're going to have what they're talking about and what Donald Trump's attorney Sawyer is talking about right here. And that is each and everything that a prosecutor alleges that a president, ex-president has committed as far as being wrong is going to have to be looked at and litigated and looked through the lens of what was his mind, what was her mind, what were they thinking, what was their intentions. It would be a complete and utter mess.
What if it did not involve any subjective element? It was purely objective. You would look objectively at the various relevant factors.
That sounds to me a lot like Blazing Game, and especially viewed through the lens of Judge Katz's separate opinion, and that may not be different than what we're proposing to the court today.
Well, Blazing Game had to do with the difference between official conduct and private conduct, right?
That's correct. I understood the court to be asking that.
No, this would apply, and just a possibility. I don't know whether it's a good idea or a bad idea, or whether it can be derived from the structure of the Constitution or the vesting clause or any other source. But this would be applied in a purely objective, on purely objective grounds when the president invokes an official power in taking the action that is at issue.
Yes, I believe the reason I think of Blazing Game is because it talks about an objective, context-specific determination to winnow out what's official and what is purely private conduct. And again, with a strong degree of deference to it.
I'm sorry. If I understood Justice Alito, he's suggesting not that. He's suggesting whether, even if it is an official act, whether you still grant immunity if that act is not plausibly viewed as within the realm of law. He can correct me if I'm wrong.
That was the question.
That, I think, would be a superior rule than the categorical denial that emerged in the trial court here. I do think it would.
I'm not quite sure why he used the word plausible, because that seems to negate, might as well give absolute if you're saying plausible, because anybody could argue plausibility. We don't even require plausible, we require reasonable in qualified immunity. So, well,
I mean, one might argue that it isn't plausibly legal to order SEAL Team 6, and I don't want to slander SEAL Team 6 because seriously, they're honorable officers, and they are bound by the Uniform Code of Military Justice not to obey unlawful orders. But no, I think one could say that it's not plausible that is legal, that action would be legal. And exactly. I'm sure I've thought of lots of hypotheticals. I'm sure you thought of lots of hypotheticals where a president could say, I'm using an official power, and yet the president uses it in an absolutely outrageous manner.
That, if for an objective determination, may well be an interesting approach to take.
So apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cite in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases.
He's exactly right. Remember that when you hear them say, oh, well, President Trump sent fake electors, that's just their words. He would say, I sent pursuant to the laws. And remember, the laws pertaining to election law, they are not uniform like you think they would be. Each and every state, frankly, has their own set of rules, their own set of laws. one side will say, oh, it was fake electors. And President Trump would probably say, no, it was alternative electors, which is prescribed by law. So just keep that in your mind as they're discussing this.
Which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment, or even
Knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to address a more higher level point, a fundamental point, which is that, as Justice Alito's question indicated, there's a whole series of structural checks other than criminal prosecution that are designed to deter these kind of, outlandish scenarios or extraordinarily obviously illegal things. And that's been viewed in this court's opinions going all the way back to at least Martin.
Where do you think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below.
I believe that's Kavanaugh, Justice Kavanaugh.
In this particular case, as adopting a categorical view, it does not matter is the logic of their opinion, because there is no immunity for official acts, and therefore, that's the end of the story. I don't really think they went wrong in Blasingame in the civil context when they engage in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article 2 exclusive power, okay, so official acts, but not within the Article 2 exclusive power. Even for those, I assume you would think that a clear statement has to be required, a clear statement in the statute covering the president if the president's official acts are going to be criminalized.
Absolutely. Obviously, the issue is, at the highest possible level when it comes to the unrestrictable powers, like as in this indictment,
Well, I'm assuming the exclusive powers are walled off and can't be prosecuted before there's a lot of official powers that are not exclusive to the president under his Article 2 authority. But for those, I understood you to be saying at a minimum, there would need to be a clear statement in the statute referencing the president so that the president's on notice and can conduct himself or herself accordingly.
That's absolutely correct. And that'd be consistent both with Franklin and Public Citizen and cases, a long series of other clear statements.
Can I follow up on that?
Ask
Because
you,
go ahead. Go ahead.
So you concede that private acts don't get immunity.
This is Amy
Okay.
Clore.
So
Amy
in
Barrett.
the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged, we dispute the allegation, but that sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to.
So those acts you.
So she's asking him a hypothetical laundry list of, would this be an official act or would this be a private act that a president could potentially face criminal culpability for? And these are his rapid answers.
Would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized, what we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public, communicating with Congress about matters of enormous
concern. Thank you.
Thank you, counsel. And what is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official?
Now, this speaking is Chief Justice Roberts. So he's kind of got a unique voice, as most of them do. Now, the thing that worries me is they're going to get caught up and all twisted up in this test of what is an official act and what is a private act. And frankly, that's troubling. I really hope that one of the reasons they are taking their time, and it's taking a long time, it's not really an abnormal long time, but it is taking a while for them to get the decision released, is because they're trying to get this right. They realize how important this decision is. I am really concerned, though, if they come back with all these different tests and try to, okay, this is official, this is private. I hope they come back with something like they did in the civil context and just simply said, the president effectively is always the president. He's always acting on behalf of the country unless something is so blatant and obvious otherwise. And we'll just have to see. But let's continue with Justice Roberts.
Official acts.
If you look at the indictment here, there's a bunch of acts that we think are just clearly official. There may be allegations that mostly relate to what the government has described here as private aim or private end, and the court should remand or address itself, but remand for a Brewster-like determination, which is what's official and what's private. The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a two-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, that's like a one-legged stool, right? Giving somebody money isn't bribery unless you get something in exchange. And if
the Chief Justice just said something that's very important. I want to make sure we don't miss it. He just said, well, if you go back and you cross out effectively everything that is official, what's going to be left? And it's like I've been saying all along, there's nothing left. These cases against former President Donald Trump will all fail on their face, even with a qualified immunity. And that's kind of what the Chief Justice is alluding to here. So as you listen to this, I just want you to kind of keep that in the back of your mind.
If what you get in exchange is to become the ambassador to a particular country, that is official, the appointment that's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward. There could be a case where it would, but if you look at even the government's brief in this case, divides up the indictment into things that, other than the electors allegations, don't really they haven't disputed that they are official acts, but what they do is say, well, we tie it all together by characterizing it as done, and these are the allegations that the court just referred to, by an improper private aim or private end. Again, that's their words, and that just runs loggerheads, dead set against this court's case law, saying you don't look at, with immunity determinations, the improper motivation or purpose.
Thank you. Justice Thomas?
Mr. Sally, in assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute essentially the blazing game discussion of that.
Okay.
But of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this. And that's the most important point there.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese.
And of course, they are now challenging the appointment of the special counsel. I believe Judge Cannon out of the Southern District of Florida is currently, as we speak, listening to arguments in that case. And there is a really good chance that the cases brought by this so-called special prosecutor, Jack Smith, this crazy, nutty, quote unquote prosecutor, will probably be dismissed in their entirety. And the short version is because his appointment is illegal. The Constitution is very clear. The law is very clear about who and when a special prosecutor such as Jack Smith can be essentially allowed. And he was never given this permission, let's just say the legal way. It may be over with at this point. We'll just have to wait and see.
and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that, we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate at any time. So we agree with that position. We hadn't raised it yet in this case when this case went up on appeal.
Justice Alito?
When you say that the official act should be expunged from the indictment, that in itself would not achieve very much unless evidence of those official acts were precluded at trial. So is that what you're saying, that the prosecution should not be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely. And we think that's just the clear implications of Brewster and Johnson and their discussion in a very analogous context.
Thank you.
Justice Sotomayor?
I'm a little bit confused by that. If
She's a little bit confused and a little bit PO'd.
you have a scheme to defraud or a scheme to accept bribery, there's evidence from which you can infer that scheme, and one of it is that the appointment actually happened. It's an official act. You wouldn't expunge that as evidence. You would instruct the jury that there's no liability for the actual appointment, that the liability is for accepting the bribe. Similarly here, I don't think the indictment is charging that the obstruction occurred solely because of conversations with the Justice Department. They're saying you look at all of the private acts and you look in the context of some of the public acts, and you can infer the intent, the private intent from them. So I'm not sure that I understand why your problems couldn't be taken care of at trial with an instruction, if the court were to find, I'm not even sure how they could, but if it were to find that some public acts could not be the basis of criminal liability.
I think the best thing I can say to that is, and I think this ties into the Chief Justice's question about a one-legged stool. Bruce.
So what the Associate Justice Sotomayor was just saying, putting it in very layman's terms, is she was saying, well, why does the president need to essentially have this immunity if at trial we can simply say that, or he could allege that this is all official acts and the jury could just be instructed to discard anything that's official? Well, it's obviously not going to work, because you still have the same problem. You have a president that can still be brought up on charges, can be embarrassed, harassed, worried, concerned. They're going to get their mug shot taken like President Trump had his taken. They're going to be out enormous cost, enormous expense, and they're going to have to actually sit through a trial. And I can tell you one other thing. The jury system doesn't always get it right. Look what happened in the OJ trial. Look what happened in the New York trial of President Donald Trump. They convicted him on 34 felonies. It was 34 separate checks that he happened to write to his attorney, effectively to reimburse the porn star Stormy Daniels. That's effectively what happened. And 34 felonies later, these libs want you to believe, the jury can fix it. Well, the jury is supposed to fix it. Our system was set up, our founding fathers set up the jury system as a check and balance measure to protect against this very thing. And I know people have often said, I listen to a bunch of talking heads saying, oh, you can't blame the jury did their job. Well, I disagree. I blame the jury. I blame each and every one of them. You did not do your job. You should be ashamed of yourself. You were supposed to put politics aside. You know what's going on in this case. Stevie Wonder can see what's going on in this case. And you should have done your job, and you should have brought back 34 not guilties.
Brewster and Johnson and subsequent cases like Heltowski versus Meaner essentially say that this is a one-legged stool problem. It will be difficult for some of these prosecutions to proceed, and that is the implications of official immunity, which is dictated in the Constitution here by the executive vesting clause. Justice Kagan?
Can I continue on in Justice Barrett's vein a little bit and ask you about some of the allegations of the indictment and whether they're official acts or not in your view? So the defendant signed a verification affirming false election fraud allegations made on his behalf and a lawsuit filed in his name against the Georgia governor.
I don't think we've disputed that that's official. I'm sorry, that is unofficial.
That's unofficial. Same for the defendant called the chairwoman of the Republican National Committee, asked her to gather electors in targeted states, falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor.
Now, remember, she's one of the liberals, too. This is Associate Justice Kagan. She's one of the 3 liberals on the court. So just kind of keep that in mind when you hear this question and go back and forth.
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case. And based on the allegations, we think it's clear he did not, that this was done in an official capacity.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
That's an excellent response by this Trump attorney. Of course, actions taken by then President Donald Trump pertaining to the election. Every president has an interest in re-election. Every president has an interest in making sure the elections are fair. Every president has the duty, has the interest in making sure that the election process, whatever the laws are, whatever the rules are carried out. You can't turn back and charge a man with a crime for pushing his rights pertaining to an election. That's what the Democrats do all the time. I made a lot of videos about that very subject. You can do a quick Google search or look on YouTube and you'll see what I'm talking about. Hillary Clinton back in 2016 said, oh, this election's illegitimate. This election is not fair, whatever. Go back and look at it. You'll see what I'm talking about. It's not just former President Donald Trump that's made these assertions. It's very normal, so to speak, very common. Matter of fact, I would argue that Democrats yell a lot louder about the alleged so-called unfair elections.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is extremely strong precedent from this court.
Does it strike you as odd that your understanding of immunity goes way beyond what OLC has ever claimed for a former president?
I view the OLC opinions here as strongly supporting us because anytime a congressional statute basically got anywhere near touching the president's prerogatives, they've said, oh, we're going to interpret the statute narrowly to avoid that.
So well, that's a different question. I mean, what OLC has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty. That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
these opinions that they're talking about, it's kind of like getting an opinion from your state's attorney general's office. If you're not sure what a law says or how a law is to be interpreted, you can always ask for an opinion. And the federal government does the same thing. They'll ask one of their agencies, hey, can you give us an opinion, for example, on if a former president can be prosecuted for some kind of alleged crime while he or she was in office? And that's effectively what they're talking about.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You probably have to have more details to apply the blazing game.
The libs love to stretch out some kind of outrageous example, and they're going to be like, are you going to let a president get away with this? For example, if he sold nuclear secrets to another country, is that an official act or is that a private act that he could potentially be prosecuted for? And of course, it's just this I got you type of questions. These liberals, these woke liberals, they want to do anything and everything they can, as Alan Dershowitz would say, to get Trump. And that's all that this boils down to. These people are willing to put our freedom, our presidency, our country, all of the greatness that our country has at risk because they want to get Trump, because they cannot stomach the thought of Trump being president again. And they can't, allegedly, if you take them at face value, they can't stomach the thought that maybe there might be at some time in the future a president that gets away with some type of crime. Absolutely ridiculous. Hasn't happened in over 200 and some years of our country's great history. And of course, they want you to believe that this is a real risk right now, and we just can't stomach somebody getting away with some type of crime. That has never happened.
Analysis, or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that a—
Well, what about if there was some type of war and the country was in disarray and president was trying to consolidate power and restore power the way it normally is and to rebuild the country? I mean, these people are ridiculous. They have no shame. They're going to come up with every example that they can possibly throw out there to make everybody question as to whether or not a president should have immunity. Of course, a president has to have immunity to do their job properly.
Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of—
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
Framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in some state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president.
Yeah, and that's because the framers never envisioned a Fannie Willis a Judge Merchan. They never thought about a Letitia James. They never thought about a woke Democratic Congress turning socialist. It's just nonsense. They never thought that we would turn against Israel and have all this crazy nonsense. They never thought that we'd be teaching men to be women and women to be men, and that we would have an FBI targeting moms and dads at local PTA meetings as domestic terrorism. Of course, they never envisioned this. It's almost impossible to come up and envision every single scenario. Thank God they did envision a United States Supreme Court that hopefully will stomp out this crazy nonsense that's going on right now.
And, not so surprising, they were reacting against a monarch who claimed to be above the law. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
See, just more nonsense. They want you to believe, they keep beating the same drum, folks, that the president is not above the law. The president's not a monarch. And when people say that, it's like a straw man, what they call a straw man argument. You keep saying that, or they keep saying, oh, Donald Trump is not above the law. Well, the inference there is that Donald Trump thinks he is above the law. I've never heard him say that. I've never heard anything close to that. But, folks, at the end of the day, he's not above the law, but he sure is not below the law. And make no mistake about it. Take New York, for example. The case was treated differently. He's not above the law, but he's not below the law. They wanted to do what they did, get a felony conviction before the election. And that's what they did. They took his case out of turn, put everybody else's cases on hold. They assigned this to Judge Merchan instead of the random lottery that everybody else gets assigned cases. And again, this case should not have went to trial for years, like most cases that they have to actually have a trial for. But for Donald Trump, they made sure he was an exception. They made sure that they put him below the law. Make no mistake about that.
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that's set forth in the very broad language of Marbury against Madison. And also they did discuss and consider what would be the checks on the presidency. And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the second volume of Farrand.
Thank you.
The reason they go back to the original Federalist Convention or the Constitutional Convention is they want to look at the records and see what were the founding fathers thinking at the time that they came up with these laws. What were they thinking when they created the Constitution? And that's kind of what's at issue here. And it's like Donald Trump's attorney is rightly pointing out, they wanted to make sure that a president did not have the type of nonsense that's going on today. And of course, the woke liberals, they don't like to hear that.
Justice Gorsuch?
Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted for bribery, presumably after he leaves office. Outside the core areas that Justice Kavanaugh was talking about, when Congress speaks clearly, couldn't a statute like that, Congress provide a statute like that would allow all manner of evidence to come in to prove the case?
I think our position is that would have to be an unofficial act, purely private conduct for that prosecution to go forward.
All right, but outside the core areas of executive power, if there is a clear statement from Congress that something is unlawful and it applies to the president, I'm struggling to see why in that case, perhaps the evidence could come in.
Yeah, the strongest possible case, in our view, is what you've described as kind of the core executive powers, the unrestrictable powers within the meaning of SELA law. But again, the holding of, for example, Brewster and Johnson that we've relied on doesn't turn on how central it is of a legislative act. It just says if it's an official act, which here we would say applies basically the outer perimeter test of Fitzgerald against Nixon, that doesn't come in.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals. I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, I didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president?
What he's talking about right here, I don't want anyone to miss this. This is the key. This is what I've been talking about. This is why they have to get this right. And now finally you're hearing the conservatives speaking up and kind of guiding him the way this conversation should be guided. If a president is always concerned that there may be a pair of handcuffs waiting for him from Fannie Willis or one of these other ignorant DAs or solicitors that frankly want to make a name for themselves, don't care anything about justice. They only care about their next election, becoming wealthy, bilking taxpayer money. I mean, come on. You're going to have someone like that being able to effectively de facto control the president of the United States? Outrageous.
To do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy.
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
I'm sorry, if the court is asking whether they
if
could
the
be...
president gives an unlawful order, call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Governor Morris said explicitly at the Constitutional Convention, that his coadjutators could be prosecuted. There is an important caveat because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes. The criminal law books are replete. But, I mean, do you agree, is that one check that's available?
Absolutely. And again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't.
That was an important point they mentioned just a minute ago, is that a president, upon leaving office, if they don't get this right, a president would effectively have to pardon themselves for anything and everything they did while they're in office. Now, as the one justice just said, the Supreme Court has not answered the question as to whether or not a president could pardon themselves. Well, that is true. It hasn't been answered. However, we always say a president is not above the law. So if he's not above the law, why can he not also receive a pardon, just like you and I can receive a pardon? So we'll just have to see if and when that ever plays out. Not sure which way the Supreme Court would rule on a question like that, but that's effectively what would have to happen if a president has any concerns whatsoever that they can face some type of criminal prosecution.
I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the recommendations clause. And therefore, we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutators, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.
Justice Kavanaugh?
Just follow up on the OLC opinions question. As you read them, and I think I read them, they articulate a clear statement rule as to this court's cases for covering official acts. And your point, I think, but I just want to underscore this, is that none of the statutes alleged here or cited here have a clear statement covering the president, therefore meaning that the president can't be charged for any official acts under these statutes.
That's absolutely correct. They're extended way beyond. I mean,
Now, that's separate from the question what's official versus what's personal. But for that bucket that is official, there's no clear statement, period.
That's right. And as to purely private conduct, we don't think the clear statement rule would be invoked. But as to official acts, these statutes, the ones charged in the indictment, are just way far afield from purporting to criminalize in clear terms the president's official acts.
And then just to clarify this, the president's not above the law. The president.
I want to clarify one thing that I said earlier. We were asking, or we keep hearing this OLC all the time. What is the OLC? Well, I've mentioned that it has something to do like with attorney generals. And I looked it up, and of course, the OLC is the Office of Legal Counsel. The Office of Legal Counsel drafts legal opinions of the attorney general and provides its own written opinions and other advice in response to requests from counsel. So it is exactly what I speculated it was, and that is, it is a opinion. It is a branch of the government that they turn to, similar to you and I would turn to our local attorney general's office on the state level saying, hey, here's a law. How and when does this apply? Or they can even say, hey, here's a hypothetical like they've done in this case. Can a president, for example, prosecuted after he leaves office for something that he did while he was president of the United States. That's what they're referring to. So I just wanted to clarify that.
It's not a king. The founders thought that. I think your point in response to that is the president is subject to prosecution for all personal acts, just like every other American for personal acts. The question is acts taken in an official capacity.
That's correct. And even those, of course, if there was an impeachment and conviction, could be prosecuted on our view. And we'd emphasize the whole series of structural checks in addition to that, which deter those and have successfully deterred presidential misfeasance for 234 years.
Then on the source of immunity, it's not explicit in the Constitution, but also executive privilege is not explicit in the Constitution. Yet in United States versus Nixon, the court unanimously said that the Article 2 executive power in the Constitution encompassed executive privilege, and the same principle presumably would apply to executive immunity being encompassed within that executive power as historically understood.
Great point by this particular justice right here. He's saying that, at least the way I take it, what he's saying is, hey, it doesn't necessarily have to be word for word in the Constitution for us to say, hey, this privilege exists, this right exists. And that's the point that he's making, that there are certain things in the Constitution that the Supreme Court has upheld as being law that are not specifically listed in the Constitution. I just want to make sure you didn't miss that point.
That's absolutely correct. And there's a very telling passage in Free Enterprise Fund where this court talked about how there's a letter from James Madison to Thomas Jefferson at the time of the founding where Madison said, hey, as for the removal power, they did not expressly take this away. So the 1789 Congress understood that it was left in place. So if the original understanding of the executive vesting clause is broad enough to encompass that, it would have to be expressly taken away, which is the opposite of the presumption that they're advancing here.
And then lastly, I think you've acknowledged in response to others' questions that some of the acts in the indictment are private, and your view is that some are official. Is it your position then that that analysis of which is which should be undertaken in the first instance by the DC Circuit or the district court?
Most likely the district court under the logic of Anderson.
Thank you.
Justice Barrett?
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench. And I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional
What if the
structure.
criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assume the risk of under enforcement by adopting these very structural.
That's a fantastic response. That's what we've been talking about. She's like, hey, what happens if an alleged crime, or let's just call it a crime, is not discovered until a president has already left office? And his answer is spot on. It is what it is. We know that by the nature of the presidency, there is that possibility that a president could get away with a crime.
Checks, as Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay,
like that.
and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think this looks like all they did was text search for president in 18 U.S. code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. Isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the things or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's example of a president who orders a coup. Let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction in an impeachment proceeding if there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be
right,
made.
But I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law. And if they don't, they could be sent to prison, et cetera, et cetera. So.
Boy, someone like this woman just makes my skin crawl. I can't stand this Brown Jackson woman. Man, she's just painful to my ears to listen to. But the good thing here is you get to see how these woke liberals think. This is how they think. This is what they believe. She's like, hey, there's people that go to prison all the time for decisions they make that are leaders. There's all sorts of people that do this. Well, she's living in a delusion, a delusional world, because there's only one president of the United States. And I would be pretty optimistic to tell you, just going on a limb here, that that's probably a very unique position with a lot of special circumstances, a lot of stressors. Sometimes there is no right or wrong answer. Sometimes you just have to make a decision. And to have it to where our presidents could actually face jail because the party coming back into power doesn't like them or wants to take them out again. These people are just absolutely delusional.
So
I say two things in response to that,
yes.
Both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
And that's the reason why she should never have been a justice on the United States Supreme Court.
He is required to follow the law. And what Fitzgerald
But he's not. If there's no criminal prosecution, if there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
All the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public
That's
oversight.
a good answer.
There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think
I'm not sure.
Actually, ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled.
Exactly.
If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, I'm also, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office?
She's just an absolute loon. But the good thing here is we get to see how these lunatics think. This is actually how these people think, and they're just absolutely batty. It's just striking that she's even in this particular position. The answer is what Sawyer is actually saying. I like most of his response. I would just add that the presidency is a very special position. Our founding fathers wanted it to where they could not be prosecuted for any alleged crimes because they knew this type of thing would happen. Our founding fathers were smart. They looked back at history and they know where the perils are, what's good, what's bad. They know how bad a king is. And they also put provisions in the Constitution that a president can be removed. It's called the impeachment process. And then, of course, the Senate can remove the president if they vote accordingly. I believe it's a 3/4 vote that they have to have. This is complete nonsense, but I'm glad you get to hear it.
It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
Yeah, I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question.
I like his response, but the only thing I would add to it is open your eyes right now and see what's going on with former President Donald Trump. Look at all the cases being brought against him in 4 different, maybe 5 different jurisdictions as of right now. They're trying to put this man in prison for life, keep him off the ballot, which the U.S. Supreme Court has already overturned. It is lawfare at its worst. It makes us nothing more than a banana republic, and we're better than this, lady. These people, I'm almost out of adjectives. Well, I can think of some, nothing I want to say on here.
Let me ask you another question about this clear statement line of questioning. First of all, I didn't see you argue that below. I don't know. I understand that you have that set of in your briefs here, but did you argue before the DC Circuit something about a clear statement with respect to statutes?
Yes, in our separately filed motion to dismiss based on statutory grounds, we extensively argued not just this clear statement rule, but a whole panel.
Right, but that's not the question presented in this case. The question presented in this case comes out of your motion for immunity. So to bring in now an argument that you didn't raise below, it seems to me you forfeited it. No?
I believe it's fairly included within the question presented.
Why?
See, so what she wants to say is because you're making an argument that I don't see in your brief, we need to go ahead and just forget it. In other words, I'd rather run this country into the ground on a technicality instead of using my brain and making a ruling that's going to benefit our nation for millennia to come. It's really just shocking, right? What adjective would you use? Put it in the comments. I'm out.
Actually, especially because the court expanded the question presented from what either of the parties submitted.
But not to statutory interpretation. I mean, that argument goes to statutory avoidance, constitutional avoidance, statutory interpretation. You asked for immunity, which is a totally different thing.
I think they're very closely related logically. The question is does immunity exist and to what extent does it? And the argument is immunity at least exists to the extent that it raises a grave constitutional question that triggers the clear statement rule. That's a really
But that's totally circular. You use that argument to avoid constitutional questions. You are asking us a constitutional question here. So it doesn't even make sense to talk about clear statement and rule.
You know what they should do with this woman? Just like I used to do with my kids. Hey, come over here, lay flat down on the floor, put your arms and legs straight out, and start going like this, and wah. That's exactly what the hell she needs to do.
It's come up in the
Big
context of an immunity question. But let me ask you this about it. I had one more question. Yeah, so what is the argument that the President of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law. I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress in every criminal statute would have to say, and the president is included. I thought that was the sort of background understanding that if they're enacting a generally applicable criminal statute, it applies to the president just like everyone else. So what is the clear statement that would have to be made in this context?
Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers. And we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
Thank you.
Thank you, counsel.
Okay, now they're going to switch to
Mr.
the other
Dreeben?
side.
Mr. Chief Justice, and may it please the court. This court has never recognized.
You're going to hear him give a brief opening statement, and then they're going to start peppering him with questions. And you're going to notice the conservatives are really going to start jumping on him pretty hard. So it's just kind of interesting to see the change in dynamics. But just to be clear, this is an attorney for the Department of Justice. I should say it's an attorney for the Biden Department of Justice, the DOJ.
Recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
They always like the rules, these woke Democrats. They always like the rules. They always like all the regulations, unless it doesn't carry out their bidding, unless it doesn't line up with what they think it should be. And you're going to see that throughout the following discussion. These people always want it their way or no way. And when it comes to President Donald Trump, we're going back to that straw man type argument. Essentially, oh, President Trump did something adverse to the election. He did not. That's an allegation. There has been no conviction pertaining to the election at this time. And as I said earlier, the election laws are very confusing. They are not uniform. Maybe they should be uniform. And a president, any type of contested election, they are allowed to employ, to offer up what is called an alternative slate of electors. Now, they will call it fake electors. I would call it, and President Trump would call it, as it is called under the law, the alternative slate for Congress to consider. I don't want to get into election law, but I can assure you it's extremely complicated. It's not cut and dry as these people would like you to believe.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article II branch, can assert as applied Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions.
Yes.
Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any.
Yeah, he just told a lie. I got to mention something about it. It's not that there hasn't been crimes before. If you notice, Clarence Thomas asked him, he goes, why haven't presidents before been brought up on criminal charges? And he outlined some things that he thought were clearly criminal or potentially criminal in nature. And then you had this counselor, basically the Department of Justice, say, oh, well, the reason why is because there has not been crimes before. What he meant to say, or I should say what he should have said, which would have been the truth, is because the president that we're trying to put in prison and we're trying to keep away from the White House is former President Donald Trump. And for him, we're willing to shred our Constitution and put our people at risk. That's the correct answer.
Any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the attorney general, and it would be a due process problem to prosecute a president who received advice from the attorney general that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore.
I think this is an important point right here. they keep referring, I'm talking about the Biden Department of Justice keeps referring to the OLC and what their findings were after they were asked by the Biden Department of Justice. They keep talking, oh, the OLC this, the OLC that. Well, I believe John Roberts, the Chief Justice, has found a problem for them, and that is that the OLC has said that a former president can be charged with crimes, but not for official acts. It has to be something that's not an official act, and that's why you're seeing this Michael Draben starting to squirm all over the place. He knows where this is going.
Or that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well. And that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said. But there's no reason to worry because the prosecutor will act in good faith. And there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the.
That's exactly right, what the Chief Justice is talking about. Throughout our country's history, we have always just basically trusted our solicitors, our prosecutors, our DAs to effectively do the right thing. We used to call it judicial discretion to prosecute what needs to be prosecuted. Basically, things that are just kind of extra. They're not really that important. They're not really that bad. Take into account who has allegedly committed the crime. Are they children? Did they not know better? Was it just a mistake? Those type of crimes we normally just leave alone. And that's kind of where the Chief Justice is going with this. We used to trust these people to effectively do the right thing. But we live in a world now, Exhibit A, Fannie Willis, Exhibit B, Alvin Bragg, and we can go on from there, that's no longer the reality that we live in.
Some cases, I'm not suggesting here. So if it's tautological and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do.
Can you believe the comments coming out of this guy's mouth? I'm surprised it did not get more attention from everyone, including Fox News. This guy is basically taking the long way of saying we can trust our people to do what is right. And that's not the case. We know the world that we're living in right now. I'm surprised that the Chief Justices didn't fall out of their chairs laughing.
Prosecutors take an oath. The Attorney General takes an oath. So, well, I don't want to overstate Your Honor's concern with potentially relying solely on good faith, but that's an ingredient. And then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
What concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions. And that has been the longstanding practice of the Office of Legal Counsel in the Department of Justice.
All right, so this is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine. I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time. And during the trial, the former president may be unable to engage in other activities that the former president would want to engage in.
Wow, what a fantastic answer. Please don't lose what this guy is saying. Samuel Alito. No wonder why the woke Democrats hate this man. This is the guy that all this flag nonsense is going on about, and him and his wife, and what type of flags they were flying. I made a couple videos about that a week or two ago. No wonder why they want this guy off the case. Listen to the wisdom coming out of his mouth. It's what I was just talking about earlier. It's not that simple to just trust the jury system to do the right thing. If a president is prosecuted, I would argue persecuted, it's at considerable loss, at considerable expense to the president. And that is what Samuel Alito is talking about right now.
And then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it.
Zach made a comment/question that I think is important for us to take a look at. If you had to impeach first, remove, and then prosecute, there would not be proof beyond a reasonable doubt that a crime was committed in order to impeach. Remember, the impeachment process is just a majority vote in the House of Representatives. Alan Dershowitz says we live in the age of impeachment. Our founding fathers were concerned that what's going on today, where a president can be removed essentially for political reasons, not for legitimate high crimes and misdemeanors. So they added into the Constitution effectively a compromise. And the compromise was that you can impeach him in the House, but he had to be removed in the Senate by a 3/4 vote, which is very hard to achieve, to actually reach that threshold of votes. That's the reason why Bill Clinton was not removed. That was the reason why, what other impeachments were there? You had Bill Clinton. It's escaping me. If you know what they are, you can put them in the comments. But at any rate, there's been 2 or 3 recently, what we call the age of impeachment. Now, remember, the standard in the House of Representatives and or the Senate is not beyond a reasonable doubt. Frankly, it's just whatever they choose to vote. There is no standard other than the founding fathers said it has to be a high crime or misdemeanor, which is somewhat confusing, at least in today's language, because a misdemeanor can be a speeding ticket. I mean, technically, it's either an infraction or a misdemeanor. A misdemeanor may not necessarily be a high crime. So effectively, it's up to the representative or the senator to vote accordingly. And unfortunately, with very few exceptions, I think Mitt Romney was one of the few exceptions, it has always been a party line vote on these type of matters. Now, if a president is impeached and removed, which has never happened as of right now, because remember Richard Nixon, he would have been removed, but he resigned before the Senate would actually remove him. So if we take this question to the conclusion, this natural conclusion, you could then prosecute a former president if he was impeached and then removed before he resigned. But that is fairly so. Some of the criticism of the way the Constitution is written is that a president can simply resign before he's actually removed by the Senate. And at that point, he could not be prosecuted. At least the judges, or I should say the Supreme Court's going to decide this question right now as to whether or not a former president can be prosecuted for official acts. We'll have to see exactly how they rule, but it's always been the understanding that once they were removed, if they were ever removed by the actual Senate, then at that point they could be prosecuted. But again, it's never happened in American history. So I hope that clears up your question right there.
And if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against most far-reaching aspects of Mr. Sauer's argument, right?
That is correct. And let me turn then to why.
Well, what about, to unpack it a little more, do you agree that there's some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn, because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371 conspiracy to defraud the United States can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically is the risk that, and going forward, the risk. So you can take all of that.
I think that the question.
Great question by Justice Kavanaugh. He's making the point that is so clearly going on right now. A prosecutor can pretty well put together any type of statute, any type of legal argument, even what's going on now, a novel legal argument, and find a way to prosecute a president once they leave office. And it's going on right now today. That's exactly what's going on with former President Donald Trump. And I like the way that Brett Kavanaugh has put the question to this other attorney with the DOJ. Let's hear what he's got to say.
Question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
I would assume that's personal. So.
Well, I think that
that's what Brewster said.
Bribery statute in 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize.
Did you hear them almost start laughing out loud completely? This Michael guy is really between a rock and a hard place. You have Neil Gorsuch, who has rightly so pointed out the Constitution makes it very clear there are certain things that a president could not be prosecuted for. And this Michael guy goes for this attorney at the DOJ, basically says, hey, I wouldn't call it an immunity. He goes, what would you call it? He said something to the effect of, I'd call it a challenge. And that's what set everybody off laughing. That was pretty funny. I think that's the first time I've actually heard that.
And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. Mm-hmm. And it in fact delays the proceedings in Congress. Now, under 1512C2, that might.
And now listen, don't let this pass you by. He's basically talking about the January 6th incident. Now, of course, the woke Dems would say it was an insurrection. And then, of course, the president would probably say, no, it was just a riot that got out of control, largely in part because Nancy Pelosi and others in charge of security wouldn't accept security, wouldn't accept troops that were offered, failed to do their job. And of course, I happen to agree with that. But Neil Gorsuch is saying, hey, let me give you a hypothetical. And of course, he's using, instead of saying it's exactly what happened on January 6th, he's just kind of spinning it a little different. But he's talking about the same type of crimes they're trying to pin on Donald Trump and others, including but not limited to essentially interfering with a government function. So I just think it's a very crafty way of looking at this. I like the way he's wording this, but let's continue.
Might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out,
a president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact.
Well, I thought you said it, that was my question.
Yes,
and you said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he left. He did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether
it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to
Assume he
violate
does.
it. Okay.
Nobody knows what corrupt intent means. We've been around that tree.
We will probably find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from.
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice, and regularly gets legal advice from the attorney general on the lawful scope of the president's activities. And we could go down two tracks here. One is that the attorney general advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of.
This guy is getting, folks, what's called a grilling. He's being grilled up and fried real crispy. Now he's trying to worm his way out of this by saying that the president's attorney general can effectively give him advice as to what's legal or not legal. And I think that that's not the way to go with this, but let's see what happens.
Kind of the First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the attorney general could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that. And I would advise you not to violate criminal law.
And then he could be prosecuted.
No.
No, if he gets a negative opinion from the attorney general, he still couldn't be prosecuted?
I would assume that most presidents are not going to take
Well, but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to the bribery statute? I, like you, understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That is correct. And it's an extremely
official building. It's a very limited mention of the
and it
president.
really, I think,
so as I understand this, there's two very limited provisions mentioning the president is included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the
Now,
fence,
Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think
that's a tautology you can't escape.
Just Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly. That's the point, which is if he's not covered by the criminal law, he can't be impeached for it. For violating it. All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was analyze what powers were being given to in the lawsuit and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept the bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, this is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right, could I go back to your brief and going back to what some of my colleagues have asked you? There appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers, correct? You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that that have to do with the president and law is that he shall take care that the law be faithfully executed, correct?
That's right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
All right.
Well, Mr. Dreeben, do you really, I mean, the presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake, he's subject to the criminal laws just like anybody else? You know?
Yes, the answer to that is yes. That's how these woke Democrats think. Just like any other job, if you make a mistake, we're going to throw the entire book at you and put you in prison. That's how these nuts think.
He's in a special, a peculiarly precarious position.
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statute.
That's not true. That's not true. That's one of the big things I love to talk about on this channel. And if you never learn anything from this channel, these are one of the things you need to make sure you understand and learn. They just asked him, so if the president makes a mistake, he's going to be prosecuted. And he goes, oh, well, that's not the way life works. That's not the way it works. That's not true. That's not true. In the world that we live in today, not just the president that they're trying to pin under this, any type of vocation that you have, unfortunately, if something happens and they deem you're at fault, you have real risk of not just civil liability, but criminal liability. That's the reason why you should never talk to the police, other than the common sense stuff like you need help, you have an emergency situation, this type of thing. But you need to keep away from the government as much as you possibly can. And if you have to interact with law enforcement, you need to do so only through an attorney, because this happens in real life. If you don't believe me, just look at the news on a daily basis. When I was a kid, if you had a wreck, you just had a wreck. We called it an accident. You know, you had a car accident. Nowadays, if you have a car accident and someone is injured, God forbid someone is killed, you have a real likelihood of some kind of prosecution under criminal law. And for today's conversation, I'm not going to say that's good. I'm not going to say that's bad. I'm just saying that's the way it is. It's different. If you run a company, if you're the CEO or you're the chief officer, president of some company, and that company has some type of civil liability or something just goes wrong, trust me, there are plenty of former CEOs, presidents, operating officials, whatever, that are serving prison time today for whatever. It happens all the time.
Statutes that are issued in this case, I think they are fairly described as malum in se statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute that particular application of that 371 conspiracy to defraud the United States to the particular facts here. But would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, I'm not, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of acts.
So what they're saying, what the justices are correctly pointing out, at least Alito and Roberts, some of the conservative justices are rightly so pointing out, is that the way these statutes are written, the president can be held under each and every one of them, which is bad for all of us.
Activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties. And particularly in a case like this one, I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes. And then Congress, in a extraordinary joint session, certifies the vote. And the president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function. You can't obstruct it through deception. You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito?
Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the DC Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there had been exceptions, right? Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I'm going to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer's one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could just, the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah,
the Department
I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the DC Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think just
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes. But I think that the other
Every once in a while there's an eclipse too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections.
That's almost a joke, what he just said. The prosecutors, DAs, whatever, have no incentive to bring charges they can't prove. Are you kidding me? A la Fannie Willis? I mean, come on.
At all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way.
Where does he come up with this nonsense? A president knows they can face criminal prosecution when they take office? Really? I never heard of that before. So when you're sworn in as president, part of it is, I also know that I may be subject to my life in prison upon completion of my term if the party that takes over after my presidency is the other party and they don't like me. And I hereby acknowledge that I'll be doing 99 to life. I mean, come on.
That way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, excuse me, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his attorney general. That's a layer
Is
of
that really
safeguard.
true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article 2 challenge at the time. I'm not suggesting today, but the idea that a decision that...
See, this goes to the heart of what the justices are basically saying. Even Roosevelt during World War II, doing what he thought was right for the country by unfortunately putting all these Japanese Americans in effective concentration camps. I believe it was out in California. If that would have happened under today's circumstances, even though the president thought he was doing what was right, he would definitely be put in prison. What is happening to Trump right now would probably look like a very soft misdemeanor crime. I mean, the president has to have the ability to take care of the nation. It's really that simple.
That was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the attorney general that something is lawful, is that an absolute defense?
Yes, I think.
Can you believe that? They're trying to tell the court that if the president consults with his attorney general and the attorney general says it's legal for you to do whatever it is you want to do, that somehow absolves the president. Where did he pull that out from? He says you can only have the powers that are granted to you in the Constitution. These people want it any which way they can get it.
I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once in history prosecution.
On the question of whether...
Yeah, see that once in history prosecution. They want you to believe it's always just an exception for Donald Trump. Folks, this is just a once in a lifetime type of thing. These people are nuts.
A president has the authority to pardon himself, which came up earlier in the argument. What's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further. And of course, this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department representing the United States.
Now, don't you think we need to know the answer to at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the DC Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who asserted a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case. Those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito.
That's a great point by Justice Alito. If the U.S. Supreme Court does not grant a president immunity, it's going to be just like any other third world country. And that's exactly what you're going to see. A president serves, and then they end up in prison once they leave office. It is really a striking thought.
There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice Sotomayor?
A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
Correct.
Now, putting that aside,
I wish in the Supreme Court you were able to stand up and say, Your Honor, I object, leading the witness.
there is no fail-safe system of government, meaning we have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail routinely, but we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through step by step all of the mechanisms that could potentially fail. In the end, if it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law, either in his official or private acts.
I think that is an assumption of the Constitution.
The only thing missing with this speech given by the Sotomayor is American music, like patriotic music playing in the background. And we should trust our systems that we have. They have worked for 200 some years. And I don't know, man. The only thing missing is that commercial with the Indian with the tear coming down his face. I mean, come on, get real.
Justice Kagan?
Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection,
yes,
that they are core executive functions.
Yes.
What are those small categories?
Pardon power.
Pardon, veto.
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received, a certain diploma, or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more of
that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects like directing troops on the field in which the president's power is completely unreviewable.
Okay, now in the next category, where we've left the core set behind,
yes,
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that the bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro. I guess the quo, actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say like what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only two that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition.
All right, so this is getting good. I know we got a little bit more left. I'm trying to see how much more is left on this here. We're getting near the end. There's something important that happens near the end that I definitely want to make a comment about. Listen, I can't believe I've been able to set this long. This is unusual for me. So I'm going to let this play. I got my earpiece in. I'm going to be right next door getting some more tea. So let's continue listening. If you have any questions, put them in. I'll hear and see whatever, but I'll be right back in about 3 minutes. Just got to stretch. Thanks, folks.
Murder would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. they also seem not really before us in the way Justice Jackson suggested earlier. What do you I mean, do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel. Stevens. It was a key tam case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate way to enforce the law. Congress, by making the law, the current executive by deciding to bring it. And since a building block of that submission is that Congress actually did apply these criminal laws to official conduct, the court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official unofficial line.
Yes.
And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually.
Again, this part is a complete and utter lie. The conservative majority is obviously not even addressing these type issues. It's always the liberals on the court bringing this up. They can call it fake all they want, but it doesn't mean it was fake, and it doesn't mean it's illegal. Like I said before, there are many instances, and it's perfectly legal, where they are allowed to make what's called an alternative elector slate. I don't want to get into the weeds on this, but I'm just letting you know what's going on.
Actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct. And I think that the DC Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
I'm sorry. There's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, this occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were serious election irregularities and that they should investigate who they certified as a president. None of this was true. The Department of Justice officials all said, this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege. But how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice. And I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations. And the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the blazing game framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse.
I would have
in
thought.
Cases.
Yeah.
Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
No, I understand that,
Okay.
but putting that aside, the distinction between official act and private office seeker.
Yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blassingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blassingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder. I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the DC Circuit placed more content consideration off limits than I would.
Okay, all right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably.
So they love to talk about in Georgia, the Fannie Willis case, that I need you to find 11,000 votes, whatever it was. If you go to the dictionary and you look up the word find, there's nothing about the word find that is nefarious, illegal, or otherwise. Find does not mean manufacturer. Find does not mean enter a criminal conspiracy to produce votes that are not there. Find, by the definition, is what we know it to be, and that is look around and make sure you didn't miss these votes. There's nothing illegal about the word find, so just remember that.
Do we look at the motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of
motive. That is right. Okay. That is right.
All right, so then we're in the non-core powers, where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes to enrich yourself, for example.
Well, bribery, all right, but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be.
You see, if they allow that core power stuff to be a factor, in other words, if the Supreme Court kind of splits the baby and they come up with like this qualified immunity or what was the president thinking, kind of like this guy's alluding to right here, it's better than nothing, but it's still going to be a disaster because what's going to happen is the president can go on trial because they put people on trial all the time to determine what was their motivation, what were they thinking, what was their intent. we call that the question for the trier of fact, the judge, the jury. That's the trier of fact. And that would not be a good thing, but I don't want you to get lost in the weeds. That's basically what they're talking about in this particular part of the conversation.
We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
well, all right, intentions. I mean, you can frame a motive as an intention, and intentions as a motive, as you well know, every day of the week.
Yes.
So let's put that aside.
I understand. Well, putting that aside, that really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable, and others that aren't. I mean, it's awkward, right? When we look back at like the injunction. Back to Marbury in the early cases, you can't enjoin a president.
Yeah.
Also meant you couldn't hold him in contempt, right?
A sitting president.
For sure.
Just can I try one more time?
Well, let me just spin this out just a second. Right, and it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, in Nixon versus Fitzgerald. That's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's reelection or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits,
he's exactly right.
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes,
Boom.
And I think I would start.
Did you hear that? We're writing a rule for the ages. I think that's probably one of the most profound comments made during this entire hearing. They're writing a rule for the ages, and they know it. This is going to be a decision that's going to live on for the rest of American history.
Start by looking at the statutes and then seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512C2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Dreeben.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, and usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produced in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by this statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence.
Yeah, I agree with a couple of you. Glass, I definitely agree with you. I definitely think the defense, the DOJ lawyer, the guy talking now, is pretty good. The problem is the facts of the case are not good for him. He's got a position to defend that I don't envy. It's the harder decision to defend. I think Trump's attorney is a good attorney, but this guy here, he's very well spoken, got a crisp voice. Actually sounds kind of, well, feminine, to be perfectly honest with you, but at least he's clear, and I think he's pretty good on his feet. Just the facts are not really good.
President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. No, I was just saying this is kind of the mirror image of that, is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution.
So
after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. Right. That would pollute the legislative
How about, I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of.
See, this is the reason why these conversations are so interesting, at least in my mind. Gorsuch or Kavanaugh here just came up with a fantastic question. He's like, would President Ford have to be worried that since he gave a pardon to Nixon, that he could be subject to prosecution by the Department of Justice for what's called interference with prosecution? It's a there's another type of crime I'm thinking of, but it's basically it's obstruction with a government function, obstruction with prosecution, just like he's talking about right here. What a great example. I didn't even think of that myself. And the problem the prosecution, the DOJ has, is trying to convince the judges that, hey, you can trust us. You can trust prosecutors. We'll always do the right thing. Don't worry about it. I don't think anybody believes that.
Presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute, because it talks about unlawful killing, did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, you know, the court's been asking you, might this result in criminal prosecution? You say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function.
And therefore, I acted lawfully.
Therefore, I acted lawfully and I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get out of jail free card.
Yes, I understand that. And I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes, it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory.
See, that's the problem here. What they're talking about with these interlocutory appeals, generally you can only appeal after a case has been completed. Then you can file a normal appeal. What they're talking about with an interlocutory appeal is it's kind of rare, but it does happen. And that is an appeal while the case is still going on. In the Fannie Willis case right now, the Georgia Court of Appeals has accepted an interlocutory appeal pertaining to whether or not she should be the prosecutor on this particular case. So it's something that is somewhat rare, but it does happen. But the problem is in the context that we're discussing of the President of the United States, and that's what the Justice Amy Barrett is talking about right now, is trying to split the baby is probably not going to work for the President of the United States. I don't know why they're having such a hard time with this. They've already given the President of the United States total immunity as far as civil situations are concerned, but they're trying to find a way to draw a line when it comes to criminal immunity. But if they don't give the president total immunity, then the bottom line is, like they're discussing, is there's always going to be a trier of fact, aka a judge or a jury. And that is the problem. There still may be a trial. There still may be an arrest. There still may be a mugshot. That is the problem. And it's going to be very interesting to see how they work this out.
As Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president.
See, that's what it boils down to. There is no perfect system. Without the total immunity, the president ends up in court. So you have a de facto deep state acquisition of the executive branch. That is what the problem is. And this is the very reason why it is taking such a long time for the justices to rule on this case. I know they are really struggling with this, but I hope they can overcome the fact it's Donald Trump, and they can, as the one judge said, write a rule for the ages.
Internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a supremacy clause issue, and the court would run a supremacy clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the supremacy clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states.
That's right.
It wouldn't be, I mean,
well,
that's my point. Like, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system. One thing that we have to worry about that might not carry the day, but, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of supremacy clause law to find an immunity. But we have been talking here about at some length on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient.
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, the normal process, what Mr. Sauer asked, would be for us to
remand for trial. That basically is a fancy way to say they want to send it back to the lower courts to have them take a look at whatever the whatever the subjects are. In other words, if they give some type of qualified immunity, then they want to go back to the lower court for them to review it and decide, for example, what's an official act, what's not an official act. That's what they mean by remanding. Let's hope that's not necessary.
With private lawyers to achieve the goals of the fraud. And as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding is private campaign activity, we still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president for their evidentiary value as showing the defendant's knowledge and intent. And we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interests in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that the evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off.
You know,
I
she's going to
think
have a lot
I
to
heard
say,
you
right?
say that
Justice Jackson?
even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient.
You know, this is actually a good comment coming from her. She just said, what if we were to decide on a rule that you don't really support? In other words, we divide up official acts versus personal acts. I mean, coming from her, that's I think that's a large move. At first, she was like, oh, you know, there's no way we're going to entertain this. But I think she sees the writing on the wall. She knows that the majority is definitely going to grant some type of immunity.
Allegations in the indictment, in the government's view, that fall into the private acts bucket, that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So that you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one. This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to.
Right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president or, can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to.
Yes,
Yes, but the first step is there ambiguity? And these statutes apply to any person. They apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution, or does he have immunity, is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress, to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in either the existing doctrine or the text. And just one data point for the court in thinking about how the clear statement rule works. In United States versus Sun Diamond, a case about gratuities that the court is probably familiar with, Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for or because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law unless the president is specifically named, which he is not in Section 201, Justice Scalia would have thought of that, and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines. Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about blasting game, and that within first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, at what level the president is going to have immunity. But I took the petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity. And so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question the way that the government has submitted, that resolves the.
There is a part coming up that y'all have to hear. I would give Trump's attorney an A, but this last part almost wants me, I want to knock him down to like a C. It's going to come up very soon. This particular recap is almost over, and then I've got some closing comments to give that I think you'll enjoy hearing as far as the way I see this particular case. But at the end here, you're going to see a question being asked to Trump's attorney one last time, and his response, well, trust me, it's worth the wait. It'll be here in just a second.
Subject to liability.
That is right.
And so we don't have to then go, well, okay, we have the bucket of official. Now let's figure out which within that might be subject to liability, not on the theory of absolute immunity, correct?
Neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity. But this is where I would draw the distinction. There are as applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine determine whether there's a infringement of Article 2.
So what you're saying is even if we reject the absolute immunity theory, it's not as though the president is, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out.
Well, yeah, she is so desperate to find a way not to grant some type of immunity to the president. It's just striking.
That the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
I don't see any need in this case for the court to embark on that analysis.
All right, the final sort of set of questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing, but I wonder whether some of it might also be mitigated by the fact that existing administrations have a self-interest in protecting the presidency, that they understand that if they go after the former guy, soon they're going to be the former guy, and they will have created precedent that will be problematic. So I wonder if you might comment on whether some of the caution from the Justice Department and the prosecutors and whatnot comes from an understanding that they will soon be former presidents as well.
I think absolutely, and I would locate this as a structural argument that's built into the Constitution itself. The executive branch, I think, as this court knows, has executive branch interests that it at times asserts in opposition to Congress so that the proper functioning of the president is protected. And I believe that that value would be operative and is operative in anything as momentous as charging a former president with a crime.
And I would also say, I think, and ask you to comment on, presidents are concerned about being investigated and prosecuted, and it chills to some extent their, ability to do what they want in office. And that's a concern on one side, but can you comment on the concern about having a president unbounded while in office, a president who knows?
Well, I'll tell you what, you talk about leading the witness. Normally in a court setting with a witness, you always have one side that's questioning, and a lot of times you'll hear objection. I mean, again, I would be like objection, leading the witness, because that's exactly what she's doing with this DOJ attorney. She's leading him to say things on the record so they can consider it that she thinks a good point in her mind. And Zach, I think you're right. She's trying to do everything she can not to allow immunity for a president. But I have to admit, I'm kind of surprised to hear her making any type of concessions or worries about leaving a president without some type of immunity coverage. I didn't really think I'd hear that from her, and I don't remember hearing that last time. But I would still say she's definitely way out there on the left on all these subjects, including immunity.
A little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has
until Joe Biden, a perfectly functioning system until the Biden administration, that they decided to engage in lawfare and indict a former president, go after him, his children, his businesses, try to take every dime the man has. Yeah, sure. We have a great tradition of 230 some years until Joe Biden.
Thank you.
Thank you, counsel. Rebuttal, Mr. Sauer?
Here it is right here. Make sure you hear this. He just finished, and the Chief Justice goes back to the other side and says, rebuttal, Mr. Sauer? Listen to this.
I have nothing further, Your Honor.
Thank you, counsel. Counsel, the case is submitted.
Oh, I cannot believe that. Can you guys believe that? I have nothing further. Oh my goodness. I have to tell you, that was just shocking the first time I heard that. That's the reason why I definitely think the other guy, this DOJ attorney, is definitely a much better attorney. He could have, Trump's attorney could have went up to the judges one more time. You always want to get the final word if you have the option to get a final word. He could have stood back up and say, listen, I appreciate the opportunity to address the court and say what I've said, but at the end of the day, we have a very unique and unprecedented problem. If you don't give the President of the United States absolute immunity, you're going to have a de facto swallowing by the deep state of the presidency by the judicial branch. Because in the future, every president that walks out of office now knows there is a good likelihood of a pair of handcuffs waiting for him by one of the 2,300 plus DAs, solicitors, whatever, that have the ability to bring charges against a former president, especially a former president that the other side abstains and just abhors, rather, and hates. It's really just that simple. So, Supreme Court, you need to do your job and protect our three co-equal branches of government. It's really just that simple. I'm not sure exactly what is going to happen with this particular case. Unfortunately, I'm afraid, let's take a look at our poll real quick. I'm not sure how to pull this up. I don't know if y'all can see it on your screens or not, but at any rate, no immunity, 7%, partial or qualified immunity. That's kind of the same thing. We'll just call it qualified immunity, 39%, and total immunity, 54%. I sincerely hope it is a total immunity type of situation. I think I voted that it's going to be qualified. I hope that I'm wrong. I hope that it is a total immunity type of situation because of all the reasons that we've mentioned here. Now, I plan on having another live stream probably tomorrow where we're going to actually read through Donald Trump's brief that he submitted to the Supreme Court. And I think it's important to do so because his attorneys have a very articulate way, as you'd imagine they do, of expressing what we're talking about here, expressing what I am saying, and expressing why it is so important that the president have total immunity. What I'm afraid of is these woke liberals are so concerned. They are just burning with concern that a current president, a future president might get away with some kind of crime. Now, remind you, it's never happened in the history of the United States, but that's how concerned they are, especially, I should say, specifically, the woke liberal justices. And fortunately, there's only 3 of them. The other ones are considered conservative. Now, I will tell you, John Roberts is normally on the fence. He's definitely conservative, but sometimes he votes a little erratically, and sometimes that happens with the Supreme Court justices. And folks, let me tell you one more thing. Don't ever buy or drink the Kool-Aid, I should say, that the Supreme Court is supposed to be a non-political type of court. There's no such thing. It may be the goal to be non-political, but they are political beasts. The entire country is a political establishment. It's just the way it is. It's the way it always has been, and it's the way, unfortunately, it always will be. It's just the way it works out. That's the reason we have the Constitution of the United States, and especially we have the first 10 amendments to the Constitution, aka the Bill of Rights. the freedom of speech, the freedom to assemble, the freedom to worship the way we want. We're all familiar with them, the Second Amendment, Fifth Amendment, Sixth Amendment, so you can have an attorney, Eighth Amendment pertaining to freedom from cruel, unusual punishments. You know, I mean, these are principles that as Americans, we hold sacred. We hold very near and dear to our heart. Like you, I'm a patriot. As I've said before, I bleed red, white, and blue. I think this is a time in our country where we all have to come together, talk about these issues. And if you are a religious person, we need to pray. We honestly need to pray together, pray for our country, pray for our leaders, no matter who they are, that they may lead with wisdom, that they may not take us down a road that leads to world wars, that leads to more division in our country. We just have to make ourselves aware. I always talk about indoctrination, lies, false truth. And we need to do that. We need to share videos like this with your friends, family. You may have someone you know that's indoctrinated, or they're just out there somewhere on the left. This video may not change their mind, but at least watching something like this, they can hear another side, another perspective of what's going on in the world that we're living in. I think it's really just that simple. I want to take a quick moment and thank everyone who's tuned in today. You still have 19 viewers on X. I appreciate that. Y'all are a solid, loyal group, and I appreciate you joining me. And thanks to everybody on YouTube. I know it's varied anywhere from the 6 we have now all the way up to 20-something, I think, at one time. At any rate, I definitely appreciate when everybody takes time and tunes in so we can have a conversation together. It's always a pleasure when you take time to tune in to hear what I have to say. And I sincerely mean that. Thanks, Zach, Gladys, my Sapphire friend. I don't want to leave anybody out. I know that you guys know who you are. I appreciate each and every one of you, especially the ones that are always joining in and supporting the channel. It is definitely humbling, and I do appreciate it. I don't take it for granted for 1 second. You always hear me say, keep that mind free. Never give up, my friends. Till next time, I am J.R. Dukes.